1, 1, 1, 1, 1, перший. 1, 1, 1, другий, 1, 2, 3. 1, 1, 1, третій, 1, 2, 3, 4, 5, третій, 2. І четвертий, 1, 2, 3, 4, 5.
Шановні гості, починаємо.
Dear guests, we're starting in about a couple of minutes. Let's wait for all of the rest. We have more coffee, so if you have a need, you can take some coffee already. Good day. I thank you everyone who has joined us today. So we are beginning the presentation of an analytical report of the Media Initiative for Human Rights, how victims of war crimes see justice. So the moderator of the event is me, Anna Rosomachina, the head of the Department of War and Justice of the Media Initiative for the Human Rights. And our today's speakers are Oksana Rasulova, a journalist of our initiative and the Legal Monitoring Department head, Lyudmila Shulkova, who is the victim of the war crime, and also Yulia Trala, the coordinator coordinator on cooperation with the organizations of civil sector of the Kyiv office of the Register of Losses for Ukraine, and Veronika Plotnikova, the head of the Coordination Center for the Support of Witnesses and Victims under the office of the Prosecutor General of Ukraine. So this report has been prepared in cooperation with the Kyiv office of the Register of Damage and the Coordination Center for the Support of Victims and Witnesses, and we are incredibly grateful for that. And so let us begin. I would like to give the floor first to Oksana Rasulova. Please. Where did you take this idea from at all? And how did we create this research? Thank you. Thank you everyone for joining us. We are incredibly happy to see all of you and to understand that this topic still is resonating and is interesting both for our colleagues and the human rights activists and the state officials, just the people who are not indifferent. So how did we come to this report? Mostly, when the people speak about war crimes or about the just court, when they speak about all of those investigations and so on, mostly they concentrate on the perpetrators, mostly concentrate also on the suspects and the perpetrators, the criminals. However, not that much we know about the victims themselves, how they treat these processes and how they feel within this legal system. Last year, even the year before the last, we started one of the researchers, and this research was about the experience of victims in the cooperation with the law enforcement authorities and in the whole justice system. What's the attitude to them? Do they feel the victim-centered approach? Are they satisfied how the whole court system is working with them? And whether they are properly explained everything? Do they understand what is taking place in the process? And the research showed that, in fact, in this sphere, there are lots of challenges and issues. We created it for conducting interviews, and we already separated certain patterns of what we wanted to delve deeper into. So to do that, last year we launched this research in the format of the focus groups, and it was also pushed by another time when we heard at the international events that for the victims it is important to be heard, which is already part of justice for them. That is a bit of an obsolete wording, even since the noughts. And I think that this part of the Western concept of justice, which is not always working, in fact, in the Ukrainian reality. Moreover, it is not always working when the histories and the stories of victims have been heard for multiple times. Because social networks are developing, the media are developing, so the people have more and more opportunities to say what has happened to them. But it is not the fact that it makes the justice closer. So every time when I heard this point at the international events that people got justice because they have been heard, I had internal confrontation within me. I wanted to get into the contradictions, and of course I refuted such words. But until we have some specific research where we can show and point out this very line and say, no, it is not working like this, until that it was very complicated and ephemerical. That is why this year we present this research. We've done it in the format of the focus groups, together with the Kharkiv Institute of Social Studies and Researchers, and I think that I need to tell more about the methodology, right? Yeah. So, we had 4 focus groups, that is approximately 2 dozens of people, and we've created for them, together with the consultations with the Coordination Center and with the Register, we created a questionnaire. So we designed the survey in the focus groups about which needs exist at the victims who deal with the concept of justice and how they see justice at all, and whether there is sense to converse about justice and to involve the aspect that the court it's mostly in absentia, so the verdicts are in absentia as well. So we conducted 4 groups, which were going on for about 3 hours each. In spite of the small number of people, they really wanted to talk a lot, to tell about their pains, about their needs, about what they themselves think about this topic, because they are not that asked about that. However, this system has to work for the sake of these people. So we After these 4 focus groups, we formed a report, an analytical report. We added a theoretical part on what justice is and a practical part, what we saw in the focus group researches. So, in the end, we added recommendations. Recommendations for the law enforcement authorities, recommendations for the state court administration, and for the coordination center, for the parliament, Verkhovna Rada. So lots of stakeholders are there, and all of them can do something in the process. Could you please formulate in a nutshell some of the main conclusions, what you saw there? Yeah, so about the main conclusions. Justice is a very abstract notion until we separate certain components. In the beginning, we showed several types of the justice which we were going to research and work with. First of all, material justice, which is the basic type of justice, if I may say so, when for the crime committed there is the proper punishment, and this concept dates back to the state of Plato. Then there is the court justice, which is about the court. The court should be fair, it should be public, it should comply with the institutional requirements which exist in Ukraine as of now. The cases should be considered during a certain period of time, and the judgments should be substantiated and motivated. But if we expand the notion of justice, we touch not only what's about the punishment or court trial, we are also coming to other concepts, and in the modern legal doctrine, there are 3 more types of justice. Retributive justice, that is the classical one. Then we have the new one, which is more restorative justice, when they don't think about criminals that much, but about the victims and their communities. And there is transitional justice, which is a hybrid model for the post-conflict societies. And it helps to cope with the mass perpetrations. And considering these diverse types of justice, we shaped the questionnaires and posed the questions. What did we find out in the situation when we speak about the help for the victims? The issue is that mostly it is chaotic. There were 2 groups which we were working with. They're already cooperating with the coordination center, and they said that they have everything much more systematized. But those who are beyond the attention of the coordination center, because of different reasons, for them it is more chaotic. They mostly don't know where to get to, who to get to, and they had a feeling that this systematic state support does not exist. In spite of the fact whether it exists or not, we speak about the emotional perception of the people, and they mostly did not feel that the system will be working for them. They saw that everything depends on the specific institutions, specific people at the places, so the human factor was really strong, and it was not always working in a positive way. The next point, what we saw, that the people were speaking a lot about the lack of systematicity with different aspects of help and support. They lack systematic, accessible medical care, legal help and assistance, and social care. All of those issues were interconnected. If the person had issues with papers or documents, then it would be harder to get some payments, it would be harder to get medical care, and gradually the health deteriorates because we are moving from the urgent needs to systematic needs and issues, and all of that is having a domino effect. And then the majority also said that they more get help from the NGOs and funds, not by the state institutions. In the state institutions, they said it was all excessively bureaucratized and that the people did not feel the proper attitude. People were accused of what has happened to them. Even the men who were released from the captivity were accused that they are not in the troops and that the war was because of them, or they said that the existent payments are already more than enough. Those were really inhumane wordings which the participants of the focus groups mentioned. Also, we said whether they believe in the opportunity to get compensation through the register of damages in particular, because now it is considered as the most probable mechanism, and mostly people could not submit the documents, the statement from the first attempt to get the reimbursement in the future. They did not understand how it was working. The system was frozen. It could be done online, but they felt that they need some offline maintenance and support. They wanted to submit the documents with the coordinator. Moreover, they were not believing that it is possible, because they did not see the examples that it would be really functioning. And several people also said that when the payments will be done for others, then we will believe that it will be working. And now I wouldn't like to waste my time for that. And in the research you will see that there were rather emotional quotes in the research, because you need to spend your efforts, because you need to memorize and to recall bad events. People are rather skeptical. Moreover, people don't always understand what the compensation is, the restitution is, and who do they get them from. Very frequently they think that it will be paid by the state, by Ukraine, not by Russia, not by the aggressor state. And it is also combined with the feeling of the offense. So we found out, when we are moving to the cluster of justice directly, how they see justice, rather frequently it is combined with the feeling of offense. That people feel offended, that the state did not do something, did not do anything to protect them, and is not helping people to live through this adaptation period, or does not allow somehow to feel more comfortable when people consider that someone from their villages or the people from the communities consider that they are to blame for what has happened, or maybe they are suspected in collaborationism, and they can see that there are no cases open against such people. So the paradox is, when we asked people about justice, they were mostly speaking about their dissatisfaction by the actions of Ukraine, but not by Russia, that it has to do something, because they can reach someone who is close to them, to the authorities and to the state, which they can really influence, because they do not believe that Russia will confess and pay for what they have done, at least by money, with money. So, in fact, it was a huge surprise for us, because we saw that during the first two focus groups. So for the next two focus groups, we changed the phrasing of the question. We started to ask people if they understand that justice, compensation, payments is about Russia as a perpetrator of what has happened and as the culprit. So then they understood, yes, surely, but the first idea, what we noticed, that they were waiting for the justice from their own country, mostly. And finally, about the court trials. As of now, according to our research, there are approximately 200,000 registered criminal cases on war crimes, and during the 4 years of the Great War, only 709 cases were in court. That's what we calculated as of 2025, the end of the year. This is just a tiny number. We cannot even calculate the percentage. The majority of these cases are in absentia, which is also rather important, so even if there is a case, even if there is a judgment, a ruling, people get the verdict in absentia. So in the end, we asked the victims in our focus groups whether it influences their feeling of justice, this fact that the verdicts for the criminals will be done in absentia. So, in fact, not that many people considered it to be significant. Mostly people pay attention to other forms of justice, but not the court system. And, of course, many people claim a much harder punishment than it is foreseen now by the criminal code of Ukraine. I think that we looked through all of the points in a nutshell. You will be able to read more in the research itself, and you'll be able to pay attention to the quotes which we did not read out, not to take your time. So I give the floor back to Anna. Thank you, Oksana. Let me add, in a nutshell, the research showed that the support for the victims exists, and it is diverse from different actors, but mostly it is not structured, chaotic, and the victims who are in the vulnerable situation by the definition mostly cannot get into it. They cannot find out how they can get what they need from the system. My next question goes to Veronika. Coordination Center is working by the so-called referral system, so it has the aim to refer the victims to different structures and authorities which have the opportunity to help them in certain needs. So the question is for the following. How did you imagine the justice is when you created the Coordination Center about 2 years ago? How did it change in your understanding during the work with the victims? And what new things you got to know from this report? Thank you, dear colleagues, and thank you all of the presentees for your interest to the topic which we will discuss today. So, in fact, we'll analyze both of what is taking place and how it is defined in the report. So, Oksana has already told about the types of justice, and she provided us a small excursion. But I am, as a person who was dealing with criminal justice during the majority of my life, and what changed for me and for many colleagues of mine when we started to work with the systems of the support of victims, our vision, in fact, has been focused too much on the concept of the retributive justice, because the criminal and procedural code does not operate with such notions separately. It deals with the verdicts, it deals with the notion of procedural actions which lead to the outcome. So, in fact, this is what's mostly we were focused on before 2022. I will tell you for sure, and many of my colleagues will be able to confirm that who are working over there in the central department, the focus, the lens, did not change, but it has been complemented. We already mentioned 200,000 of cases, and we are conscious saying that we won't have 200,000 of verdicts. And the people who are mentioned in these cases need to get their outcome, which sometimes is really different from the one which the criminal justice is created for. I would say that the focus of justice has changed for me in the way that working on achievement of justice shouldn't be done only by criminal justice, and all of the expectations shouldn't be only from the criminal justice. This is the story when we are speaking about more holistic approaches, because now, for instance, I understand that working with the victims on international crimes without the changes in the systems of social care and support and how it is these procedures are implemented on the places, it would be much harder, and I would say it's not realistic. And also working everybody separately in our own sphere, just saying that according to certain restrictions and we are moving only in a certain way, it will never lead to the outcome which the victims are expecting for. It would lead to the situation, please read the report in more details, and you will see that it leads to certain quotes from the report. From my own experience of the 2 years of work with the victims, I may say that the respondents were really very cautious with the choice of their words. Or maybe the editors who took the quotes were really cautious, because people are mostly speaking out in a different way. And I personally saw, and my colleagues for these 2 years saw totally different stories. We understand that in the majority of points everything starts and ends in the human dimension. Who is working at a certain position, and who was the first contact, or maybe the second contact even, after which the human shaped his or her attitude and vision. But sometimes the opposite happens. But what influenced my understanding the justice, that is just procedures. That is definitely about fair procedures, not only in the system of criminal justice, because we are over-procedured. we have too many of procedures, but fair procedures, just procedures, which have a unified, combined approach, which is based on the realistic expectations of the victims and the availability of the resource which we have. This is the point which we are discussing at every event. We are appointing a very high threshold for ourselves because we are in the process of the full-scale war. And many of the recommendations which have been provided, for instance, I am a big fan of the concept of justice, of transitional justice, but the recommendations of transitional justice has been formed and implemented in the countries of the post-conflict period, but we are in the depth and in the conflict. But it doesn't matter for the victims, because the issue, what you can get and how you can recover, at least to find some ground under your boots, is the question of here and now. So, coming back to the question how our understanding of justice changed, I think that the big finding was that the understanding of justice of the representatives of criminal justice was really different from the understanding of our beneficiaries, of the victims. And the second point is that these approaches can be changing. It is mentioned a lot in the report about the coordination center, so I'm really grateful that they came to us with such a request in the beginning, the request on cooperation. Later I'll have the opportunity to tell about that a bit more. But we are saying about how important it is to pose this question for ourselves and to find responses which would be honest. Then one more question comes to you. What do you think? Well, we are speaking a lot about different aspects of justice and that all of them are not working separately in our situation. So what do you think? Is it possible that in Ukraine, in this awful laboratory which gives birth to new concepts and categories, there could be a new understanding of justice for the victims in international crimes? I think that it's already emerging and crystallizing. The issue is that how we'll move on in this process. Because let me say again, from your own point of view, from what we see, what we do, we see lots of points which show us we don't have anyone to study from. We had to shape these methodologies, mostly to create them something united from different parts, and this understanding of justice under the conditions when there is the war of aggression and the majority of people read about them as separate lines in the textbook on international humanitarian law, and it turned out to be reality, and it is taking place in the civilized world just several hundreds of kilometers away from you, then I think that the notion of justice is the notion of which is really grounded in the good sense of this word, and it's very practical. That we shape it here. Definitely it's not a biological laboratory or Soros-funded thing. Thank you so much. I need to tell you that we have an air raid alert and the threat of ballistics. If you'd like to, you can get to the bomb shelter. Thank you. So, we are going on. Thank you, Veronika, for your speech. Yulia, then, the representative of the Kyiv office of the Register of Damage. As you've seen already, the report showed, among other issues, some of the complications on the submission of statements to the register, and even before these focus groups in our media initiative, as the people who are helping the people to submit their documents, we knew about those systematic complications. So, whether the conclusions of this report were interesting for you, do you have an intention to use this information and to work on this issue? Thank you for the question, Anna. And also I'd like to express my gratitude to you personally, because I know how you spent lots of efforts so that this research could take place, and the whole organization of yours. So answering your question, let me say the following. Surely we were really getting acquainted with this report with really high level of interest, getting to know the conclusions which you were drawing. So let me say the following. The information which was there was not unexpected for us, because the register, in spite of being international, it is totally not separate from reality. We face, we meet, we communicate with the victims who are in fact submitting the documents and who are the applicants, with the civil sector, which provides huge practical consultation support for the applicants. So we would like to say that sure, we acknowledge the complications, the hardships which the applicants face in different categories, somewhere more, somewhere less, so we are working on that in a systematic manner. But still I would like to mention that the register, in fact, is not a separate thing. The whole process of the submission of an application is inseparably connected with an interaction with the state. In particular, as the Ministry of Digital Transformation and DIA app, because thanks to their developments and interaction with the register, the submission of these applications is possible, and the response, the reaction to those hardships which we can see. A kind of the lyrical detail of this context is the following. So far, in the world history, the Register of Damage for Ukraine is the first compensatory institution which has been created and is already functioning before the end of the war, before the end of the armed conflict. So, on the one hand, it gives us the opportunity to react much quicker. On the other hand, it gives us certain hopes for the right to err, to mistakes, because really we are working on the mechanisms from scratch. So it's not always working in the best way possible, because it's never been researched, analyzed and tested before during many of the years. In fact, it is being implemented as a concept and an idea which is already embedded in it. So about a practical part, a very practical part. In particular, just recently, about a fortnight ago, several powerful NGOs which are providing consultation support and practical support to the most vulnerable groups of applicants delegated their best experts who are working on the registers for the technical meeting with the representatives of DIA portal, Ministry of Digital Transformation, the register, and we were working on some of the categories step by step from the perspective of the average applicant, how he or she sees that, and which obstacles he or she faces at step 1, step 2, step 8, step 12, and so on, in all of the categories. So, some of the processes to create more user-friendly mechanics need some more time, and we hope that in some time everyone who will make an attempt to submit an application For instance, again, repetitively, because I was reading closely, not every single applicant was able to submit the documents and to force themselves to make several attempts. So they will finally see that the system has become more user-friendly and simple. Simultaneously, I'd like to mention also the following. The register is only a part, a 1/3 of the whole compensatory mechanism, and it's just a comment to that part of the research which was about non-material, intangible constructs like beliefs, expectations, understanding of justice. And in this context, I would like to add a couple of words about the compensatory mechanism as a whole. In particular, I'd like to try to comment on the absence of motivation to get to the register from the perspective of disbelief in justice, disbelief in the fact that the aggressor country will be paying compensations and reimbursements and so on. So the despair. The register is only one of the 3 components of the international compensatory mechanism. It is working for almost 2 years, and in fact, in the end of December last year, the next step has been done. It was not done fully fledged way, but the next step was conducted in the implementation of the compensatory mechanism to the full scale. So we are speaking about the creation of the compensatory commission. So a certain resolution has been voted for and signed instantly by 36 participants, which is in fact an unprecedented way. Because again, during the voting, not a single convention of the Council of Europe ever got so many signatures. But now, the question is, like the respondents had, when the payments will start. And the payments will never start without a necessary condition, when the compensatory commission will start its work. After it's been created, it will start its work. And only after that, we can speak about some of the time limits, time frames, and expectations on payments. So before the creation of the compensatory commission, there is a condition, ratification of this convention, at least by 25 countries, and one of it, and we hope that Ukraine will be the first. So 24 are left, right? As in the ratification by Ukraine, well, we shouldn't be doubting in the fact that Ukraine will ratify it. So we are having high expectations that the process of ratification will take place during this year, maybe half a year, maybe a bit longer, maybe quicker. It is hard to predict anything specific. So even the applicants, I would say, on the one hand, if we say something specific to the applicants, that the payments would start in 2 years, that would be really giving them more motivation for the submission of documents. But on the other hand, we understand that the process of the creation of the compensatory commission does not depend exclusively on Ukraine or the register itself. So we wouldn't urge to the higher expectations. And the last point, in a nutshell, I'd like to say that the more applications are submitted, the bigger will be the incentive for the international community, so that these processes of ratification, in particular of the convention, would take place quicker. And in this context, I would like really to express my gratitude to the CSOs, civil society organizations, which find the opportunities and time and funding and their current projects to provide consultations and support to the most vulnerable layers of the affected population. Because as the practice shows, the tragedies, the stories which took place are frequently about the most vulnerable categories. Thank you. Thank you for your answer. Yes, really. In the report, you can follow and you can monitor that there is the whole distrust and disbelief, despair in the work of the register. It's a shame, but the person who is not the expert in international law cannot understand all of the details and cannot understand that we don't know the date of the payment of compensation. So we are optimistic about the future of the Register of Damage. Thank you. I'm giving now the floor to Ludmila Shumkova, who is a victim of war crimes, and her relatives as well. So, could you please tell about your story in a couple of words? My story is very old and long, but I will try to be as quick as possible. Now it is working. Okay. So I will try to be as brief as possible. So, as my relative, my nephew, is the ex-political prisoner of the Kremlin, and our family turned out to be under the monitoring of FSB and other special services of Russia since the beginning of 2013. And in 2013, Maidan started, the revolution started. My nephew was a very active participant of Maidan events and the active participant of the Right Sector political party, so he was introduced into the search base of the Russian Special Service since 2013. So in 2017, he was kidnapped from the territory of Ukraine and convicted in Russia for the participation in the Right Sector. He stayed there for almost 4 years in jail for the participation in the Right Sector, and he came back to Ukraine in 2020. So they tried, the Russian Special Services tried to provide 8 years of administrative overview. It was interesting, but we understood that something was taking place. Their courts are not that stupid. People with legal education are working there. So if the citizen of Ukraine should be under 8 years of administrative monitoring, it would be interesting how they would implement this ruling. So we understood that if the full-scale invasion would take place, and we understood that it will take place because we knew what Russia is, what Russian jails are, what special services from Russia are. So as I am myself from Kherson city, and I was living in Kherson during occupation, then during the full-scale invasion, when the Russian regular troops came in and other armed formations of Russian federations also entered the city and were involved, as well as Russian Guard and Center E, and there was the hunt announced against my nephew because he stayed in Kherson and he was the head of one of the underground formations. He was drafted during the occupation and he was accomplishing certain tasks and missions. Of course, there was the whole search of his and the whole family because they wanted to find a little link which would lead to him. Whatever we tried to do to hide, still the Russian special services found us, and with Alexander's mother, I was detained by Russian special services, so I found out to be in their illegal detention. That's the story. Thank you. And let me also mention that Lyudmila did not take part in the focus groups because all of the participants of the focus groups are anonymized. So Lyudmila is telling about her own understanding of justice independently from the report. So, could you please tell, after all of the things you lived through and all of your relatives, what is justice for you? How you imagine it? And what's the place in this understanding is for the verdict or ruling in absentia? How important it is for you? Well, justice as it is a very complicated and philosophical category. And for each of the persons, justice can be different. Every single person sees justice in a different way. For me, justice is not only a punishment of the perpetrator or a criminal, it is also, well, of course, material compensation because we lost some time and health, so some compensatory mechanism. Besides that, some medical rehabilitation, in spite of the fact that the law was adopted, the law on social legal protection on the persons who were deprived of personal freedoms and their relatives, their family members, and also several bylaws were adopted. But as for rehabilitation, it is not working how it should work. Surely, especially it's about the persons who were deprived of personal freedom, who are coming back beyond the processes of exchanges or liberation. If the person is released on his or her own, when the occupants let him or her go even at the occupied area, it is still very hard to get through this medical care, to get rehabilitation. Mostly, you are forced to get to some foundations or CSOs or NGOs which have the opportunities and capacity to organize such rehabilitation, medical care. So, in spite of the fact that several bylaws were adopted, still there is the certain separation or distribution in two categories, even among the persons who were deprived of personal freedom, liberty. There are people who are coming back during the exchanges, and according to these documents, they can get through post-isolation period to get some rehabilitation, but the people who are coming back on their own, they don't have this access, or the access is too complicated to rehabilitation. For me, it's important to feel that it would be a security guarantee and that will never take place again. But I don't feel that, because besides the necessity to punish the war crimes, I still think that the people who are traitors or who committed collaborationism activity need to be punished as well. For more than 17 years, I was working in the state institution, which belongs to the Ministry of Healthcare. And what can I see? People who collaborate under occupation go on working in such institutions. There are no criminal cases open against them. Some of them are even promoted. And I am the person who was hiding, who cannot live in Kherson city. I don't even get some full salary, for instance. For me, it's not just. It's not fair. Besides that, as for reparations, I understand that it's the international law, that there is the certain mandate of the register, but it's such a shame when the political prisoners who were imprisoned because of the aggression of Russian Federation, which started in 2014, they were found out beyond the process of reparations. I understand that it's about international law, that certain conventions have been signed and voted for as resolutions, but it's a pity that reparations start since 2022, not since 2014. I heard that this issue has been raised for multiple times. There were many people who were illegally detained since 2014, mostly on the territory of Donetsk, Luhansk regions and Crimea, and the people who were taken to Russian Federation, who stayed there in jail and managed to come back. It's not fair. Lyudmila, it seems to me we lost one more point in Anna's question about verdicts in absentia. Yeah. Yes, mostly those are rulings and verdicts in absentia. I'm not having any illusions that the perpetrators will be found. Yes, of course, they are identified. Some of the war criminals are identified. There can be cases which were even given to the courts, and there are court proceedings and legal proceedings going on, but mostly the verdicts are in absentia, and those people are living on the territory of Russia. They live their best years with their families. They can travel. So even having a verdict in absentia, they go on living their best lives, and they never felt that there was a verdict against them in Ukraine, that they are war criminals. Even what was done by the journalists of Suspilne, who monitored the social media profiles of the people who used to be in Kherson city and who were the supervisors of the detention center. They can even visit Turkey and, of course, Crimea, because it is under occupation. They stay there as well. So, yes, seems that there is a verdict against these people. They have been identified. They are considered to be war criminals. They get the verdict which is foreseen by the Criminal Procedural Code of Ukraine. But still, I understand it as a lawyer, but I don't understand it as a human being, because they don't feel responsibility, the liability which they should feel. Thank you. Well, in fact, you could hear in the answers of Lyudmila lots of questions for the future. The question of transitional justice, lustration, the memorialization and memory, and this is just the voice of one victim. So it seems to me that it really gives us hopes that now, under current conditions, we are sitting and getting into the notion of the justice for the future. And now, I thank all of the speakers, so we can move to the Q&A session. Reflections and comments among the audience. If you have any questions, we'll be happy to answer them. I hope the reflections are ongoing in your minds, which we don't see that much. And this presentation has become useful for the participants. So maybe you've got any questions on the methodology, on what you already looked through in the report, to any of the speakers. Anna, could I please comment on one of the points which was mentioned by Lyudmila while the audience is thinking on the questions? I would like to comment on the point about the temporal jurisdiction of the register and how it has been working since 2022. Yes, it is true. So far the issue of expansion is not solved. But certain steps have been done. In particular, this convention on the compensatory mechanism, which I mentioned before. In the preamble, there is a statement that nothing could be an obstacle to expand the time frame and the mandate of the compensatory commission to make it work since 2014. We understand that we move from the issue of very specific legal issue of international law to our internal one. The participant states which will have to ratify the documents, which will have to vote for and create commissions, they are also the representatives of their own countries, their own citizens. and they assess, in fact, what they can see as of the current time. So soon there will be the 4 years of the full-scale invasion. Let me tell you the following. The categories are multiple. It is impossible to register all of them, and they are not sufficient for the decision-making process. What do I mean by that? Surely, it will be easier for the countries to come to the conclusion about the necessity to expand this time mandate of the register and the commission if they see hundreds of thousands of applications, not just dozens of thousands. That is why our common task is, both of the state and the CSOs, is to help everyone who has a wish and intention to get to the register, to tell their story, and thus define their requirement and their need of justice, at least in the form of compensation. Thank you. Yulia, thank you for your comment. We also hope that gradually there will be more categories, but so far that's what we have since 2022. So unfortunately, that leads to certain feelings. I could see there is a question from the audience, right? Yes, hello, Tatiana Katrichenko, the head of the Media Initiative on Human Rights. So I have a question to Veronika. When we speak about 200,000 of criminal cases which are registered, and we understand how many victims can be in these cases, and obviously we understand that in each of the criminal cases it will not get to the court, and so the perpetrator will not be identified. Still, how can we speak about that with the society, with the people who are staying at the occupied and deoccupied territories, to explain this mechanism? And how we can prioritize these cases, which in fact we can investigate together, so that this overall understanding and feeling of justice could be in all of the 200,000 victims, and maybe even more. Thank you. Well, you see, I was muted. Well, of course I did it with my own hands. How can we speak? Well, like we should speak with the grown-ups. Secondly, thank you that you mentioned prioritization. We need to say the following. Yes, there can be certain cases where we can get evidence, where we have them, and which will be worked on quicker because of certain obvious objective reasons. But also, we should explain that such crimes will always be relevant. And we should also mention that I always mention the example of ex-Yugoslavia, because the year before the last I visited the court trial in people who are now at the occupied territories is incredibly important. It is hard for us to cope with that. It is hard to get data and verify them according to how it is predefined in the criminal procedure. And of course, when we provide this communication with the people who are still at the occupied territories, and I can speak about that from my own experience, because I'm from Kherson region myself, and my family was in Oleshki under occupation for 25 months, with the understanding who I am. We understand that the smallest contact with criminal justice, the smallest contact with the state authorities, can put the life of a person in danger. And let's say it directly. When we have such a probability, we should wait to collect evidence in any other way. But making conclusions, we need to be honest, and we should show what can be done and what will be done. Can I also add, if you don't mind? Because knowing all of these cases, it's also a topic we are working with. In particular, Anna is working with that. It is rather actively promoted as the need to speak not only about war crimes, but about crimes against humanity, when we can combine and group smaller cases into a bigger cluster and to pay more attention to the commander's responsibility. Because if there is some systematic crime in one settlement from the same military unit, the commander will be liable and responsible for that. And it can lead to more outcomes than just separate verdicts when it's impossible to prove everything and to identify everyone. Let me also mention one more thing. Now we are finalizing a work, my colleagues from the War Department are finalizing the work on the update of the strategy of prosecution on international crimes for the next years, and there they mention prioritization and commander's responsibility. Those are the ways which justice is using moving on. We will communicate about that as well. Perfect. It's really good that you're doing that. Audience again, good day. Maximo Gipienko, I am the deputy head of the Center for Release of the Captured. I have a question to all of the participants of today's event. What could be the recommendations to the state authorities about, as we said, that there are 200,000 of criminal cases? That's a lot during such a period, and we understand that justice will take place when the perpetrator will be punished or responsible, depending on what has happened. But for that, 200,000 of cases need to be investigated and finalized. And it takes time. Some people speak about 20 years, 30 years. We have experience of different countries, which can be diverse after the end of the combats. People are searching for justice during many years, and they are still searching for it. As of now, what do you think? What else we need? Where the state sector is not working enough so that to work on these 200,000, and on the other hand, to get to this justice which we are all expecting for, as usual people. More attention, communications, other things which maybe are not connected with the criminal procedure, and with lengthy things like restoration of justice through the reparations and so on. That is really a lengthy idea. So what about live, real, specific proposals as of today? What should we look into as the state, or as law enforcement authorities, the sector of public authorities for social protection, healthcare, and so on? Thank you. Thank you for the question. Well, before answering this question, I would like to in fact warn you and to be really cautious. All of the 200,000 cases need to be investigated, but it will never take place. Even during the peaceful time, these crimes can be identified about 40% of them, well, depending on the category, of course. But it's about the peaceful time when we have access to the crime site and the crimes are not that massive. All of the hundreds of thousands of registered cases will not be investigated, and many of them don't have means to identify criminals. Let's consider that as well. So let's look realistically at that, and there are no recommendations which can be complied with to investigate all of that, as we are grown-ups in the real world. As for recommendations block in our report, there is one. There is one recommendations block. Let me be frank. While writing it, we faced a certain issue. We tried to make them as specific as possible, but still they are rather abstract. And even now they are rather abstract. Why? Because the report tells us about really massive, high-scale issues which cover all of the spheres of the state activity. So to formulate some of the separate recommendations, you need to create a separate document which will be much bigger than this report. So overall recommendations exist. They have been formulated. More detailed recommendations have to be formulated and will be during the close cooperation with the public authorities. So it is too early to say anything specific. Let me also try to say something about this topic. The main thing Well, it's really very hard to take everything into consideration. But the main thing, what we heard from the victims at the focus groups when we asked them how the things can be improved, many of them said that they need some coordinator who will accompany them. That's what the coordination center does, as we understand from its name. But it's not always when the people, especially the ones who are not working with the coordination center, who don't get help from this center, they don't always have a person who will do everything possible so that this process with the documents, with the status, could be as comfortable as possible. So many people said that there should be such a coordinator, not only in the coordination center, but also at the public authorities where they get to rather frequently. This structure, in fact, is working in different formats. Those could be, for instance, the case management in healthcare, when there is a case manager who accompanies and maintains the patient in different doctor's visits, in different institutions, even where this person is not working, still accompanies this person to the specialized clinic to provide assistance. It is working with the veterans, it is working with the military in some of the institutions. So in fact, the ones who have the status of a victim, we could implement something like that as well. Or, for instance, they also mentioned that there should be some personal proposals so that the person, when, for instance, he or she is coming to the register or to DIA app, to have already some simplified set of digitalized tools to submit applications, to get to know which documents are needed, where it can be done, what needs to be brought to get this or that certificate. So all of that should be focused on the experience of the people and to use certain products. And we also provided the recommendations in the end for the state court administration so that they could introduce the position of the coordinator in the courts, so that this person could in fact, accompany the person during the procedure, what should be expected, when you could be summoned, when you shouldn't be there, what the lawyer is doing, why you need to prove that the crime was committed, because many questions are raised among the people who don't know what criminal justice is. Yes, you can read more in the end, and there is not only about recommendations, but also recommendations from the victims themselves. Pay attention to that as well, please. Okay, I'll cope with this device finally. So, as for recommendations, I'm, as a representative of the public authority, I cannot recommend anything to other public authorities because we are speaking about that at the operational level and the policy formation level. We are not only speaking about that, we lead to certain outcome. This is one of the results, that is about the practical implementation. That is the resolution of the Cabinet of Ministers 1775, which is about the support and support of the civilian hostages who are coming back from the illegal deprivation of freedom. That was what was mentioned today. Those who are coming back beyond official exchange could not have access to lots of services and systems, but now everything is described in the way that first, they are definitely coming to us, of the prosecutor's office and certain departments on the work with victims, and secondly, regional military administrations have their own zone of responsibility on the formation of such services and access to them. Every time when we speak about a certain idea, or a certain issue, we begin to form the answer how this issue can be solved. And for instance, the focal points issues or the case managers issue for those who have been affected by war in different institutions is important. We had such a process with the Ministry of Social Policy on the framework law, on basic support for the people affected by war. I hope and I know that this process is being recovered slowly. But speaking about separate recommendations to certain authorities is possible only when we can see the needs and specific drawbacks of the procedures. But first and foremost, as for me, that's about us to get into the shoes of the victims and to understand what way they are going along with. Because you will never understand what the issue is to get documents through the Center of Administrative Services Provision if you don't know that you need some money for that. And people who left the occupied areas don't have money, and without these documents you will never get access to any help and support. And secondly, who are you in the criminal case? We don't know you, we cannot identify you. Well, you are speaking about the state fee. Yes, we understand what we mean, sure. And lots of other nuances, because global ideas moving to the operational procedures, the devil is in the details, and fixing these details is much cheaper than creating certain structures. And one more point should be mentioned. This slide has been shown, and could you show the slide again about our contacts? We, the coordination center, and our chapters and departments are working in 9 regional prosecutors' offices. We are the part of the prosecutor office. We are working with the prosecutors and investigators, and sometimes we need to translate from the legal language to the human language, and vice versa, from what the victim wants to the language which can be achieved in the procedure. And we are already those case managers. I would say that we are even concierge service of the victims, because the person feels lost, feels really differently when first faces the experience of the crime itself, and secondly when the person faces the state and the judicial system as it is. And it's very important for us, and you can see that in the research. Communication. We are working with the people because with their informed consent, the prosecutors and investigators give us the data about them. So I could see the security service colleagues from here, and I am happy that this communication is working with the national police, and the people can come on their own. We have some information about such people from our colleagues from the CSOs and, in fact, NGOs. So if this data is spread, I would be happy. We have 3 new departments in Lviv, Chernivtsi, and Odessa regions, and we are working so that this network could become a system in all of the prosecutors' offices of the regional level, and so that this approach wouldn't be only for the international crimes, because we all know that the war is not helping to decrease the violent crimes number. So thank you for such a platform. Thank you. If there are no more questions left, thank you so much to our guests and listeners. I also thank the UNDP program, thanks to whom this report has become possible, and see you soon. I hope we'll see each other soon.